All right, so we're going to get started. Well, I know some folks will be trickling into the room, but let's go ahead and get started so we don't fall behind. So special thanks to AUSA Vanessa Richards and Special Agent Andrew Dodd from the FBI for talking with us about existing threats and a lot about prevention. As I said earlier, the focus of today is going to be about awareness and preparedness, and prevention is certainly built into that. The threats that they talked about this morning are real. We know that they're real, and we know that they cause a loss of data, and they can also cause interruption to your business. So what is all of this? What can all of this cost? Well, that Ponyman Institute study I referred to earlier from 2017, it was out in June of 2017, we expect an update soon, estimates that the cost of a data breach in this country is about $225 per record. That cost is substantially higher in the healthcare industry at $380 a record and higher in the financial services sector at $336 a record. According to the Ponyman Institute, about $79 of that cost is for direct costs like your legal and your forensic exam and your notifications, whereas $146 of that initial $225 cost are indirect costs like damage to your reputation, loss of customers. It's a huge part of that underlying loss. While we know that you can't prevent these incidents from occurring, we do know that you can significantly reduce the damage to your reputation and the overall cost through preparedness and immediate action. That study that I referenced a minute ago also found that if an organization has an incident response team and an incident response plan, and that team is activated as soon as there is an incident, that per record cost goes down by $19 per record. They also found that if an organization uses encryption, that per record cost goes down an additional $16 per record. All of this is proof that preparation is everything here. We need to think about an incident before you're dealing with the incident. You have to plan for it before it occurs. And that's what we hope to do here today. We are going to walk through a cybersecurity incident that results in a data breach. And what we hope to do is give you the tools and highlight the important considerations so that you can go back to your organizations and put appropriate plans in place and make sure that you don't make the sort of mistakes that we're going to point out this morning. So to help us walk through that plan, we've got a team here, and I'd like to introduce them to you. First, we've got Dan Kagan, who's an associate. First of all of these folks are members of our privacy and cybersecurity group. Dan Kagan is an associate who is part of our healthcare group, and he will be serving as our data breach lawyer today. To his left is Melissa Federico. She's an associate in our litigation and insurance practice groups, and she'll be providing perspectives on insurance and on litigation risks. To her left is Susie Walsh. Susie is a partner in our Trust and Estates department, and Susie will be playing the role of a communications and PR expert. This is normally a role filled by someone who does communications work and not a lawyer, but Susie has agreed to play this role because the communications information is so important. And then we've got Brian Fisher, who is a counsel in our business and finance department. Brian's going to talk to us about important board considerations and possible SEC considerations. And then finally, we've got Stephanie Subkoyak, who's a partner in our healthcare department and the co-chair of our healthcare department. And Stephanie's going to talk with us about what would happen if the entity that we're talking about today was a healthcare entity. And we're going to look at the specific issues that relate to healthcare. So let's get started. On the back of your agendas, in order to make the story a little easier to follow, we've provided the scenario. So let me introduce the company to you, and then let me read the scenario to you, and we will get started. So our company here is Foodie Inc. Everything I do has something to do with food. I couldn't help it. Foodie Inc. is a gourmet food company in Middle Connecticut. It prides itself on using unique technology to reduce production costs. Because of its high-quality food products and innovative business model, the Food Network just named Foodie Gourmet Food Producer of the Year, increasing its local and national notoriety and sales. Foodie employs over 750 people, including college interns and students. Foodie sells to individuals and commercial customers. So what's our scenario here? Well, about an hour ago, the FBI contacted the IT director at Foodie Inc. and reported that the FBI found Foodie's sensitive business documents on the dark web. They appeared to contain proprietary information about the company's processes and recipes, and the FBI discovered these documents while they were investigating other cyber crimes. The IT director was weary of the call from the purported FBI agent and didn't act on it. Later that day, employees on the production floor reported a problem that caused production to halt. The IT director did not recognize any correlation between the call earlier from the FBI and the production issue. 2 days later, now on June 14th, employees reported receiving a ransomware message when attempting to access customer information. The ransom message demanded 10 Bitcoin within 7 days, and as of this morning, 10 Bitcoin was about $68,000. Okay, so the IT director is now on board that there's a problem, and likely that his job may be in jeopardy. He assembles his IT staff of 3, including their college intern, and to discuss and troubleshoot the problem. And he also then notifies the CFO, who is his boss. The CFO is unsure of what to do, and after considering their options, the CFO calls his trusted advisor, his accountant, and asks what to do next. The next day, June 15th, the accountant gives the contact information for a data breach lawyer. So, Dan, Foodie has called you. What is the first order of business here, and can you describe what your role is?
Sure. So the first order of business is really to find the problem, to stop the problem, and then resecure the systems. Everyone needs to be focused on that first and foremost, and the idea here really is to just try and stop the bleeding as soon as possible. While a lawyer can't do that for you, you do want to involve outside counsel as soon as possible, because outside counsel, what they're going to do is they're going to engage the outside forensics firm to stop the exfiltration of the data, eliminate the cause, and then determine what information was breached, which will affect the response. And it's really best to have a lawyer engage the forensics firm, to have any findings and recommendations try to be protected by attorney-client privilege. And then often, outside counsel is going to have various contacts with forensics firms. So hopefully, although it's the weekend now, we can get a quick response and a team working to figure out what happened. And then as Foodie starts to learn more information about what happened, it may want to consider contacting the FBI again, as they may have had more information about the bad actors. In fact, here, although we're going to go down the scenario a little bit more, Foodie really just should have called the FBI agent back as soon as possible and realized that there was a bigger issue going on here.
And hopefully the message from this morning was well received by everyone, that you should be working with the FBI when you have these sorts of issues. And Foodie certainly should have done that here. As Dan said, the first order of business is really stopping the current threat and securing the systems. And one caution for you. Most organizations have internal IT staff, and many of them are very talented people. But unless they are specifically trained in forensics and using certain skills and tools and techniques to assess systems on a forensics level, you really shouldn't be relying on your internal people to do this assessment. You should be looking at external people. Make no mistake about it, your internal IT team will be critical for communicating with the expert, and they'll also be really important throughout the entire incident response process. So in addition to the data breach lawyer, the FBI, and the IT forensic expert, one other important outside contact exists at this point, and that is your insurance company. Melissa, what can you tell us about what Foodie should do now with respect to insurance?
Sure. Every insurance policy is going to require notice as soon as possible. Notice of either, actual knowledge that a breach has occurred or any fact, circumstance that an informed person would reasonably believe is likely to give rise at a later date to a claim. Now, there's certainly situations in which the meaning of that provision needs to be litigated, but if you can choose your own adventure, and in this scenario, there have been plenty of things that would have triggered the notice provision in the insurance policy, and you need to get the insurance company on board immediately, and there's really good reasons to do that, because the insurance company, a lot of times, sometimes it's complimentary, sometimes you pay for the additional benefit of pre and post loss risk management services. And so the sooner you get the insurance company on board, the sooner you can get the benefit of, the policy that you purchased.
And the risk of not notifying your insurance company timely means they can deny coverage. And so it's important to reach out to them as soon as possible. And as Melissa said, they may have resources for you, and they might be immediately available to you. For the purposes of our scenario, we're going to assume that Foodie has some sort of coverage here, but it's not great coverage. But let's just assume that they've got some form of coverage. Addressing communications is also going to be an issue that we need to look at immediately, or that Foodie needs to look at immediately. Susie, what should Foodie be thinking about even in these early stages?
So I'm going to provide a shining example for you all of why you don't let your company lawyer handle your PR. Having said that, I do know a little bit and want to talk about the importance of PR, public relations. You can, at the end of the day, recover your systems, successfully prevent or perhaps defend lawsuits, but if your customers end up hating you and leaving you for a competitor, you have lost because of this breach. So, early in the crisis, Foodie isn't going to know what it's dealing with. It's got to, nevertheless, take control of its own narrative, decide who will be the public face of the crisis, not the company lawyer, and how it's going to control its own narrative. So what it's going to want to do early on is bury its corporate head in the sand and say nothing and hope the story goes away, which is wrong. It can't simply say nothing. The faster Foodie publicly responds, the faster the story will actually dissipate. So what might Foodie do? The first responder rules, in a nutshell, are tell it all, tell it fast, and tell it yourself. Don't say no comment. You can't tell it all initially because all is an unknowable thing. So Foodie, if it has the luxury, should work with a crisis PR manager. But in any event, whoever is managing the PR is likely to advise it to acknowledge the breach. It's pointless to say nothing happened, nothing to see here, move along. It should remind the public and its customers that a thorough response to a cybersecurity event takes time. It should indicate that it will provide periodic updates to the public and to its customers. Maybe it thinks about, depending on the size of the company, a dedicated web page or a telephone hotline. Its PR managers, response team, whoever, should be monitoring the media and tell the public that it's brought in the right resources to manage the event. So the last point Foodie should remember is not to overpromise early on. Don't say, this is all going to be contained within X hours, or we've got this solved. Just say, we've got it under control, we've got the right people here.
Thank you, Susie. Well, Foodie has lost the opportunity here to tell its story first. Remember the college intern? He loves Twitter. He posts on June 15th, so cool to be working with the FBI on a hacking situation at Foodie, hashtag FoodieHack2018. One of your employees follows the intern's Twitter account, brings it to Foodie's attention and says, what happened and was any of the employee information impacted? So Susie, what now?
So I did mention the importance of controlling its narrative from the outset, and I also would have mentioned the importance of having a robust response plan in advance, but Dina, clever as she is, has thwarted that. So this provides a prime example of why you want to plan in advance, and one of the aspects of an advanced plan would be limiting internal communications. So you wouldn't have had the IT team grab the intern because they wanted another hand on deck. That's bad. If it had a press and social media policy, that would have expressly forbidden interns and employees from posting on social media about any public events or cyber events. And it certainly should have been more careful to contain internal communications on day one of the crisis. So you have to remember, reporters are going to report, college students are going to post, and unless you prevent them from doing so or you manage the information you're giving them, you're going to be sunk.
Thanks. Well, while we're on the subject of communications, Brian, what should Foodie be saying to the board? I mean, at this point, production has halted, and thanks to our intern, the public knows what's going on, but we don't really have any information to share yet.
Sure. Unfortunately, there's no bright line rule as to when to report up to the board of directors. The duty really arises both from the board's duty to monitor the operations of the company and the actual officer's duty to report up, and it's a materiality test. It would depend on the size, scope, and complexity of the problem. Here, where we're shut down, our operations have been shut down completely, I would say that the board should be brought on sooner rather than later. If it was a small, quote-unquote, small breach, and we could still operate the majority of our business, maybe the board is notified after the scope of the problem is determined. I would note that if we did have a plan, you would want to make sure that you stick to the plan and that the board is notified in accordance with that plan to protect yourself. And then another point for consideration is, boards of directors determine corporate policy. One would think that the decision to pay ransom would be a policy decision for the company, and that should really be made by the board of directors and not an officer simply trying to resolve the situation.
So Brian mentioned an incident response plan. Of course, Foodie didn't have one, so there was no plan here for them to follow, and we're going to talk a bit about that and examine that a little later. Good news, Dan was able to get a forensics expert in over the weekend, which is no small feat, and that forensics expert really has two main tasks. First and foremost, as Dan already mentioned, it is to secure the systems and get rid of whatever is attacking the system. The second is to determine how the attack occurred and what information was impacted. Those are the primary goals of the forensic expert. Also, because there's ransomware in the mix here, someone needs to be assessing the backups. Because in a ransomware situation, backups are everything. So someone's going to be taking a look at those backups as well. So it's now Monday, June 18th. Someone has determined in the IT department that Foodie has backups. Good news, they've got backups, but they've never been tested, they're not easy to upload, and we don't really know if there's going to be any usable data on them. And it will take a couple of days to determine if, in fact, they can use that information at all. Keep in mind our timeline here. We got 7 days from June 14th to do something. It's now June 18th. It's going to take a couple of days to see if we can use the backup information. The time is running short. So Dan, tell us about Foodie's options with respect to the ransomware here.
Thanks, Tina. So this isn't really going to be a great decision. I think that good news more sounds like bad news. It's important to understand some context here to ransomware attacks before you really start to weigh what Foodie's options are. So historically, it used to be that ransomware had a pretty good reputation. And by that I mean if you paid your ransom, you were actually going to regain access to your systems. The logic behind that being if the bad actors didn't hold up their end of the bargain, no one was going to be bother paying the ransom and they'd be put out of business. However, now that ransomware has been around for a while, people can purchase ransomware products on the internet and then try and get get data that way. There are a lot of people that are just using it nilly-willy. And so 20 to 50% of those that pay the ransom actually never receive access to their data again. And this could be for a couple of reasons. Either the bad actor could be unsophisticated, such that they don't even know how to return your data, even if they had the best intentions of doing so. Or more maliciously, the bad actor really never intended to provide you with the decryption key. So additionally, Foodie also has to keep in mind that the ransom here is in Bitcoin. They can't just send a check or send a wire. And it can take days to set up a Bitcoin wallet in order to make the transfer. And the due date here, as Dina mentioned, is 3 days away. So we really don't have a lot of time to make the analysis and figure out what the decision is going to be. But as Brian mentioned, ultimately, it is a business decision. While the FBI would probably say don't pay the ransom, Foodie has to weigh its ability to run its business without the data that it doesn't necessarily know if it has a backup for. Obviously, if it had good backups, the decision would be more clear. However, even if Foodie pays the ransom, there is a good chance that the criminal won't unlock the data. There also is the chance of recidivism here. If Foodie pays the ransom, they may become a target for future attacks because now the bad actor knows that they're vulnerable and they're willing to pay to receive their data back.
So more on the importance of backups a little later, but for now, Melissa, will insurance policies cover ransom?
It depends. When you're applying for insurance, there's really a menu of options, and so it really depends on what you pay for. But the role of insurance with ransomware is increasing. If 2014 was the year of the retail hacks and 2015 was healthcare data breaches, in 16 and 17 there has been an increase in ransomware and cyber extortion, and the damages, so the amount of ransom that they're demanding has increased 15 times over from 2 years prior. So it is increasing. Sometimes the ransom seems like a low number, and so from the insurance perspective, the insured may feel, well, maybe I don't need to put the insurance company on notice, maybe I have a high retention, and so resist that urge because, as Dan mentioned, sometimes you pay, you don't get the data back, it can really snowball, and so it's just, again, a trap for the unwary, and to really stress that early notice is important.
Well, our friends at Foodie don't have that cyber extortion coverage, so they're not going to get any coverage for the ransom request here. It's now day 6, June 19th, and we finally have a report from our forensic expert. First and foremost, that forensic expert has imaged all of our systems. You heard the FBI say earlier that oftentimes they want copies of that malware. If you just wipe everything off the system and don't keep copies of it anywhere, then you're not going to be able to do that. You're not going to be able to further examine what happened later on. You're really operating on 2 tracks here. You need to secure your systems and remove that malware as quickly as possible, but at the same time, you want a copy of what's happened so you can keep track and make sure that that doesn't happen again, and possibly give it to the FBI for use in some sort of prosecution. So what we learned from the report from the forensic expert is that this was caused by a phishing email that went to the CFO, and it gained the login credentials of the CFO, who had administrator level access to the entire system. And so the hacker created access accounts for himself and spent days, possibly weeks, in the system without being detected. Our firewall logs also indicated that employee data and some business information was exfiltrated. So we know that that has left the building. We also know that the disruption to the production on the floor was related to malware that the hacker installed. The forensic expert has removed that, and that system is ready to be operationalized once again once they can figure out the customer information issue, which is currently hampered by the ransomware. We also know that on the way out of the system, the hacker installed ransomware on the customer information server that also had some sensitive business information. As a side note, it is not common to have these 2 types of attacks happen at the same time. The low and slow attack, where someone gets into your system and hangs out there for a while, and also ransomware. We wanted to illustrate both of them, so we're going to talk about both of them today. It's not an impossible scenario, but certainly not likely as, and at this point want to thank Jeremy Parkins from Synactech, who's here and who I go to give me information on this, on the IT stuff. I am not, for those of you who know me well, don't come to me if you have a computer issue. So thank you to Jeremy. So we now have this background information from the forensic expert. Dan, why is this, or how is this information important to you as a data breach lawyer?
Sure. So the forensic report and the analysis from the expert is important to me as outside counsel because the types of data that are involved and the states of the effective residents that are involved really determine the legal notification and reporting obligations. And because the United States doesn't have a unified reporting requirement, outside counsel needs to look at the statutory language of each state to determine what information needs to be notified and to who it needs to be notified. And so, Dina, can you provide me with the information of the affected residents in the states that are involved? I understand because Foodie had a lot of college student employees, there could be a number of affected states.
Yeah, sure. And so there's two categories of information. The sensitive business data, you're on your own. There's no reporting requirement for that. You lost your business stuff. That's on you to figure out how you make those repairs. The individuals, we know that the employee information was exfiltrated. Of the 750 employees, about 700 of them are Connecticut residents, but as Dan said, because of our large college employee population, about 50 of our employees are residents of 10 other states, including Massachusetts, New York, and California. So, Dan, does that mean that we now need to look at the statutes in each of those 10 states to determine how we need to do notice and reporting for those residents?
Unfortunately, that is exactly correct. Breach notification and the corresponding notices that are required are not one size fits all. So whether notification is required depends on each state's definition of what is going to be personal data or personal information. And I'm not going to go through each of 10 states because that would be a little bit ridiculous, but I will, and time consuming, but I'll try and give you some overview of what the differences could be between each state. So in all states, a name and a social security number will trigger the state's corresponding data breach notification statute. But if social security numbers are not involved, then there are many variations. For example, California includes health information in its definition of personal information. Luckily here, Foodie doesn't have that information, but Connecticut does not. And additionally, the Connecticut data breach law applies only to electronically stored information, whereas Massachusetts does not have that component. Additionally, different states have different time frame requirements for reporting. Some states describe the time frame requirement in more vague general terms using phrases such as soon as practicable, whereas other states are going to have a firm deadline such as 90 days. However, even with states that have specified time frames, the expectation here isn't that you're going to wait to the 11th hour to do your notification. You should really try and notify the appropriate agency and or individual as soon as you're able to do so. You also need to consider whether the statutes require any state agencies that you need to report to. In Connecticut, it requires notice to the Attorney General, but Massachusetts requires notice to two different agencies, both the Office of Consumer Affairs and Business Regulation and the Office of the Attorney General. Then when it comes to the notice itself, the content also changes from state to state. Massachusetts is specific in that the notice to the individual affected does not include the nature of what happened in the breach or the number of affected residents, whereas in other states it's really typical to describe what happened to cause the breach, and you want to provide the individual with a little bit of an explanation as to what happened and the types of data that's involved. Next, because here Foodie unfortunately lost information that included social security numbers, some states are going to require Foodie to provide free credit monitoring to affected residents, and that comes at a cost to Foodie as well. Connecticut is one of those states. The current statute requires 1 year of credit monitoring. However, the AG's office has really been requesting that organizations provide 2 years of monitoring when social security numbers are involved. And that statute has actually been amended to require 2 years as of October 1st. So as you can see, with 10 states involved, logistically, it's really a bit of a nightmare when it comes to reporting, when you have this many individuals in states. But because the notification letters are not one size fits all, as I mentioned earlier, it's not really as simple as writing one notice and then conducting a mail merge to try and get all these notices out. So depending on the size of the breach, you may want to involve some logistic vendors that assist with mailing the letters out, setting up a call center for you for questions that your affected individuals are going to have, and to provide the credit monitoring.
And just a follow-up note on the call centers. While these call center services can be expensive, they start around $10,000, sometimes they're absolutely necessary. If you expect to get a large number of calls relating to an incident and you don't have the staff to answer the phone and to appropriately respond, then it's worth the money that you'll spend. I can tell you that we had a breach incident that was similar in size to this last year, where the client decided it was worth spending the money because it was a W-2 incident and it was in tax season, and they knew they were going to get a lot of phone calls and that their employees were going to be upset, and they wanted to make sure that they were able to answer those questions and that the people who were answering the phone knew how to respond to these types of calls and requests. When you work with one of these call centers, you actually give them an FAQ and you give them information that they use so when they answer the phone, they know how to answer questions. It can be really, really useful. So don't write it off as an option simply because it's a little on the pricey side. You may actually have insurance coverage for it, in which case you should use it. Another note about the Social Security aspect of this. When you have Social Security numbers involved, there really is some time sensitivity. Even though, for example, the Connecticut statute gives you 90 days to provide notice, to the extent that you can provide notice sooner, you should, especially if you're dealing with a W-2 tax season issue, and we've seen quite a bit of that. We know that in the last one of these that I handled, within 48 hours, fraudulent tax returns were filed. So one of the things that's really important is we want to make sure that we're taking care of our employees whose information was impacted and that you're getting them the information they need so that they can protect themselves in the short term. That will go a long way in keeping them happy and encouraging them not to badmouth you and not to sue you, quite frankly, in the end. So now that we have now that we know about the cost for all of these things, well, actually, let's talk about the cost. If the estimated cost is $225 per record in this country for a data breach, we've got 750 records that are at issue. It's about $170,000 just for the data breach portion of this incident. We also know, we learned today, that Foodie can use its backups, and it's going to use its backups, probably because it doesn't have insurance coverage to pay the ransom and didn't want to take the risk. But it will take another 2 days for them to load that data to be able to use it. So they're going to be out of production for yet another 2 days. So we've got a bunch of costs that are adding up here. So Melissa, what will the insurance provide for with respect to all of these different costs that are adding up?
Sure. The answer, again, is really it depends on what you paid for. It depends on what you applied for and the coverage that was available and the coverage that you asked for. So coverage under cyber risk policies is divided into two parts. There's first-party coverage and third-party coverage. First-party coverage is coverage for damages that your company incurs as a result of a data breach. Third-party coverage provides coverage for damages that third parties incur as a result of your company's data breach. And so when we're talking about these costs, restoring the backups, we're talking about coverage under the first party coverage part. And that typically provides coverage for depending on what you paid for things like breach response, business interruption, and data restoration. Not only to, both to assess whether or not you have sufficient backup tapes to be able to restore the data, and then if not, recreating as best you can. So provided that you purchase that coverage, it will be there.
And obviously all of this is something that you should be talking with your insurance brokers about in advance to make sure that you have appropriate coverage for your particular operation. So if you need that coverage in the future, you know that you've got it. All right, so now it is June 20th, and customers are calling. You've been out of operation for almost a week now, and customers are angry, and they want to know what's happening. Susie?
So needless to say, Foodie does not want angry customers. Angry customers soon become former customers. So it needs to be proactive, meaning it either accepts all the calls or proactively makes calls to its customers. Communication is absolutely key. Foodie's customers don't really care about its data breach. They care about their orders. So Dina talked about one option, which is the dedicated third-party call center, an outside call center, which is experienced in dealing with a huge volume of angry callers. So that's one option. Another one is to simply have your existing personnel take the calls and train them appropriately. Perhaps there's interim options, like if you know you're going to get flooded with calls, perhaps you can do what the airlines do, which is you call and they tell you it's a 55-minute wait, and before you hang up the phone, they say, but we can call you in 55 minutes. So then you're not quite so angry. That's maybe a middle ground. So you can tell from my last point that I fly a lot. So let me analogize something I've experienced many times with airlines. You're at the gate. You're in Hartford, let's say, flying American Airlines, which often connects to Philadelphia, which is never on time. And so you hear the inevitable delay, and then you hear the inevitable second delay. And then eventually your flight is canceled and you're just really angry. And if you're like me, you don't fly American Airlines anymore. But once in a while, you'll get the gate agent that actually is either empowered to do something or maybe just does it on his or her own and says, gets on the loudspeaker, guess what, folks? This is the second delay. My experience with this route is that the second delay is always followed by a cancellation. Come on up to the gate. Let's rebook you all right now. So the flight, that my experience as the passenger is roughly the same. I'm delayed. Eventually I'm getting to Philadelphia. I'm probably not missing my flight, but I'm happier because at least the gate agent did something and didn't just say, yeah, we'll let you know. So that's a good point about proactivity. Try and reach out instead of, and maybe empower your customer call center or your employees to address angry customers in one of several ways. Maybe that's free food. I don't know, but Foodie could strategize with that. And finally, I've been talking about external communications. Foodie needs to think about internal communications. So there were employee records that were released, and those employees are going to be very concerned about that. So Foodie needs to talk to its HR department and have them talk to its employees so it doesn't have both angry customers and angry employees.
Great. And while we have a moment, we'd like to thank Andrea Obstrom for giving Suzanne some great background information so she could play this role of communications PR expert. Andrea is that expert and has great experience doing that. So now the malware has been removed. The backups have been uploaded, so we don't care about the ransomware anymore. The system is secured. Dan has created a strategy for notification and reporting obligations. And so before we talk about what the potential fallout could be, there are two notes that I'd like to make. The first is we've avoided having anything that would have triggered breach notification under GDPR, the new European data privacy regulation, for a whole host of reasons. But understand this, if someone within the European Union, someone's information were implicated here in the breach aspect of this, there would need to be a report made to the European Data Protection Authority within 72 hours of the incident, and then possibly also notifying the individual based on the circumstances. We could spend days talking about GDPR. We won't do that today. The second note that's important for you to be aware of is that to the extent that credit card information was at issue here, and it's not in our scenario, but it's really important to know that if credit card numbers were impacted, that PCI or payment card industry standards would likely apply and may require things such as a second forensic exam, not the exam that you paid to have, but a second one that you'll also have to pay for, which goes directly to PCI. And there could also be other requirements that you have to meet under your contractual obligations. So be aware, if credit card information or financial account information is impacted, there can be other things you need to think about. So getting back to our scenario, what is likely to happen? We've secured the system, we've gotten things back online, we're back to producing. What happens next? Dan, do we have to be concerned about the government entities that we reported to? Do we have to be concerned that they're going to come back and ask questions?
So because there were 10 states involved and each of them were probably implicated by each state's data breach statute, then in all likelihood, each of those states is going to have the authority to investigate the incident and assess fines or other penalties for lack of compliance. And so government agencies may investigate and ask for supplemental documentation from Foodie. And this documentation may include copies of Foodie's incident response plan or other policies or procedures that Foodie had to handle the breach. In significant incidents, it is possible for government agencies from different states to collaborate with one another for enforcement purposes. But really what it comes down to is, importantly, if the explanation that Foodie provides in its report is deemed incomplete or inaccurate, or if it raises even more questions about the manner in which Foodie responded to the breach, then it's really more likely that a state's going to ask follow-up questions and impose any penalty allowable by statute. Thus, I think it's very important to emphasize that when responding to state investigations, you really need to try and be thorough in order to stave off any serious follow-up inquiries.
And I'm going to put the state on the spot because I understand that the AG's office is here, and to the extent that Jeremy, John, do you have anything you want to add, any advice you want to provide to the group on reporting to your office?
Our webpage was just updated to reflect the change in the law that Dan provided. There are additional things that we request in a report beyond that which is statutory, and a lot of that is for data capture purposes, so we can report back out, hey, the big industry last year was such and such industry. So to the extent that you can provide that additional information on that webpage, that mitigates the follow-up.
Right. If you Google Connecticut AG data breach, you will get to the page that gives you the information on what those points are that have to be included in your report. And you're also going to get the email address. It's like ag@ct.gov or Thank you. So all of that is available on their webpage, and you really do need to follow the instructions for providing all of the information that's requested. Thanks for chiming in. Sorry to put you on the spot. It's also worth noting that another government agency is flexing its muscles lately, and that's the Federal Trade Commission. Not likely to be an issue here for Foodie because it's not big enough of an issue, but when there is some indication of an unfair trade practice or an organization that's lying to its customers about what it's doing, the FTC may jump in. For example, Uber's had a couple of run-ins with the FTC. They had a data breach back in 2014 that resulted in part from an insecure third-party cloud service provider. And then Uber told all of its customers, no worries, we fixed it, not going to happen again. 2 years later, same thing happens again. So the FTC, under its Section 5 authority, says to Uber, this is an unfair trade practice and a deceptive trade practice because you've told consumers that you fixed this problem and you didn't, in fact, fix the problem. So they've entered into a settlement agreement with the FTC that requires something like 20 years of record keeping and auditing on top of having certain privacy policies in place. As a small footnote, there was a rather large Circuit Court of Appeals decision on the LabMD case questioning the FTC's authority to direct certain privacy programs, but we'll see how that plays out in the future. But just keep in mind that there's another organization out there that watches things like security incidents and data breaches. Okay, so what about lawsuits? Melissa, Foodie is the victim here. They didn't cause this. This was not their fault. Could they still be sued for what's happened?
Absolutely. So I mentioned that policies have two different coverage parts. There's first party and third party. This would fall under the third party coverage part. And that part typically provides coverage for regulatory liability. So that's the cost, defense and indemnity costs for claims of administrative regulatory proceedings, fines. Also covers costs for crisis management and remediation. So things that you're doing, you promise the affected individuals that you will do credit monitoring, those types of things are covered. And lawsuits. And we're actually seeing an increase in two different types of class action lawsuits. There's consumer class action lawsuits. And there's been a handful that are percolating and going through the courts, and courts are actually split right now on how they're addressing those lawsuits because, typically there's been a breach, but the question that the courts are really hung up on is, has that breach caused you damage? And so that your personal information has been disclosed, but has anyone used that information to impersonate you, to, empty your bank accounts? And so it's an issue of standing, and courts are really all over the map on that. The other category of class actions that are increasing are securities class action lawsuits. There's a more recent class action against Intel for, it was a disclosure in January 2018, not of a breach, but of a feature that makes the processor chips that it manufactures potentially vulnerable to attacks. And so the complaint alleges that Intel made false and misleading statements about the security, that when they revealed the unreported flaws, which were referred to as meltdown and spectra, the updates that were necessary to address them were slow to come out, and that the shareholders complained that it caused the price of the shares to drop. The complaint also has a count against Intel's CEO, because apparently the allegation is that he was aware of this flaw months prior and had sold $37 million of his own stock prior to disclosing, which is, not good. So there has been an increase. Class actions are very, very costly to defend. Takes a very long time to make its way through the courts, and so it's...
Other lawsuits that Foodie should be concerned about, while the SEC isn't, it's a great point, something to be concerned about if you're a publicly traded company. Foodie won't have to worry about that, but they do have commercial customers, which means in all likelihood they've got contracts with those customers that may require certain things. And so there may be lawsuits based on breaches of those contracts, and you may also have other legal obligations that are outlined in those agreements. So those also need to be explored to see what kind of obligations might be out there under those other contracts. So Susie, we've also got the issue of reputational damage here. What can a company do? What can Foodie do to address reputational damage?
So the first thing it wants to do is to tell its customers and the public that it's gotten everything under control. It's regained control of its systems. It's taken corrective steps to prevent a recurrence. In this context, you probably can't specify what the steps are, but you get the point. Foodie shouldn't be afraid to acknowledge the inconvenience that the business interruption caused its customers and to apologize for that. There's nothing wrong with that. There's no harm in that. And then it needs to go about repairing its customer relationships. Maybe it simply tells the customers, we have upgraded everything, we've retested all our systems, and we're going to continue to do that. Maybe it gives them free food. Maybe it gives them free shipping. Maybe it can't afford to do that. It needs to figure out what it can afford to do. And eventually, all crises fade from memory. Foodie just wants to make sure there isn't a quick recurrence.
Very good. So before we go on to exploring what Foodie could have done differently here through this incident response, since we're actually through the initial part of the response, we wanted to change the scenario just a bit to give you a couple of different perspectives. So we're going to pretend that Foodie is a healthcare company. And we're going to ask Stephanie to tell us what additional considerations or concerns might be out there if Foodie were a healthcare company and we were dealing with healthcare information.
So as Dina set it up, in case this wasn't exciting enough, if you're in the healthcare field, you also have to worry about HIPAA and its requirements layered on top of everything that my colleagues have been talking about. I find in what I do on a daily basis that most healthcare providers and their business associates and subcontractors at this point are pretty facile with the privacy rule. They understand the privacy rule and its implications on not only electronic but paper and spoken health information, the conversations in the elevators, the receptionist at the window, things of that sort. However, the security rule is far less understood, particularly by the smaller healthcare providers, the smaller business associates. And the security rule was really meant to operationalize for electronic information the privacy rule. It requires the use of, I believe the exact language is reasonable and appropriate. administrative, physical, and technical safeguards to protect health information that covered entities and business associates create, use, maintain, store, or, and the or is key when dealing with business associates, transmit. Any one of those things, and you're in the security rule. In general, it requires 4 things: that you protect the confidentiality, integrity, and availability of all your electronic health information, that you identify and protect against reasonably anticipated threats to security or integrity of that information, that you protect against reasonably anticipated impermissible uses or disclosures of the information, and last but not least, as was really focused on this morning, workforce training, that you ensure compliance with the rule by your workforce. Absolutely not to be underestimated. Thankfully, as those of you who deal with this know or should know, HHS set the security rule up to be fairly flexible and scalable. There's absolute recognition that, for example, a small physician practice with 4 doctors on Main Street is going to have different reasonable things it's going to do to deal with security than an enormous multi-hospital health system across 8 states. Absolutely, that small practice is held to a different standard. That said, there are 3 types of safeguards that run through and that should be very much paid attention to regardless of the size of the organization. Your administrative safeguards, things such as your performance of your risk analysis upfront and on an ongoing basis, designation of a security official, your training. Second types of safeguards are your physical safeguards. There was conversation about that this morning too. The fact that you need to ensure access of all your physical equipment while making sure that the people who are authorized to have access can actually access it when they need it. And last but not least, most on point with our conversations today, your technical safeguards, making sure that you have reasonable transmission security and other technical processes in place for the type of entity that you are. All things that will go a long way, not only to getting your staffs organized and making sure your data is protected, but things that will serve you very well if something happens and you are investigated. You don't want to be caught sort of having been totally unaware on those points. Since the scenario we talked about was part of it anyway, was ransomware specifically, in case any of you are from healthcare entities or business associates in the room and aren't aware of this, HHS put out fairly timely, I would say, going back a while now, but fairly timely when ransomware incidents gained popularity among the bad actors, specific guidance on ransomware. Generally speaking, HHS does not impose any different standard in terms of the presumption of a breach unless you can show otherwise in the ransomware context, but I'd caution you, and I think Dina would say the same, the fact that they opined on it and opined fairly quickly means that HHS and OCR very much care about ransomware. They know it's out there, and if you're going to want to come to the conclusion, if you've had a ransomware incident at the end of your analysis that it wasn't a breach, you absolutely need to be on your toes in explaining why your encryption worked or why the otherwise unauthorized access didn't, in fact, happen. Last but not least, I'll mention timelines. Dan touched upon this a minute ago. HIPAA, generally speaking, requires notification to affected individuals within 60 days. Some states are longer than that. Some states are shorter. One of the most common questions I get from healthcare providers and business associates when they think they may have a breach on their hands is, oh my goodness, do I really have to send patients different notices? By and large, the answer is no, but you need to be on your toes and make sure you meet the shortest requirement. So if, for example, HIPAA 60, you're in a state that's 90, you need to meet that 60 or sooner to help protect your patient base. And then for real excitement in the healthcare field, when you're dealing with HIPAA, if you have more than 500, as those of you who deal with it likely know, more than 500 affected patients, you're notifying the media, which brings us back to Susie and the heightened PR issues that go along with having to make a notification of that magnitude.
Great. Thank you for that, Stephanie. So there's also been quite a bit in the news lately about publicly traded companies and data breaches and security incidents. So Brian, can you tell us what different considerations are out there for publicly traded companies?
Sure. So a publicly traded company or a company that reports to the SEC basically has an additional level of disclosure leveled on top of what they're normally disclosing in the event of a data breach or regarding cybersecurity. For the actual breach itself, consideration needs to be made as whether or not it's an 8K event, whether or not a current report has to be filed with the SEC to let the world know that a breach has happened. People sometimes get tripped up. If you're disclosing information to a broad group of people but not disseminating it publicly, you have to give thought as to whether that is material non-public information that would move the market if a reasonable investor knew about the information. The second level is your annual filings, your annual disclosures. In 2011 and 2018, the SEC published some guidance on what should be included in your 10K, your 10Q, and proxy statements regarding cybersecurity. Basically, if the risk of a cyber breach is material to your company or your business, there should be discussion in the management discussion analysis, in the risk factors, and in the proxy statement there should actually be a discussion as to what the board of directors is doing to manage this risk. And the SEC is really looking at this. Recently, Altaba, which is the former Yahoo, got hit with a $35 million fine from the SEC, which stems back to a 2014 data breach. Hackers got into the company's system, stole over $100 million worth of 100 million accounts, their information, their personal information, their login credentials, their home addresses, phone numbers, etc. Reported it up the chain to senior management, but then sat on it. They didn't disclose it publicly. They didn't disclose it in their SEC reports. And then in 2016, while they were in the process of a transaction with Verizon, it came to light. And it caused big problems for both the transaction and Yahoo as a company. The purchase price between Verizon and Yahoo was reduced by hundreds of millions of dollars. And Yahoo was investigated by the SEC. They just settled an $80 million class action lawsuit and were imposed with a $35 million fine by the SEC.
In other words, it doesn't pay not to disclose. And so those rules, even though it's for publicly traded companies, I think those same principles, Brian would agree, apply when you're, even if you're not a publicly traded company and you're in the middle of a deal and you know that there was a breach situation, that needs to be disclosed as part of a material disclosure. Okay, so now that we've been through the response, we have the benefit of Monday morning quarterbacking what happened here. So what could Foodie have done differently? Well, quite honestly, just about everything. Foodie did just about everything wrong here, other than hiring Dan as their data breach lawyer. That was a smart thing for Foodie to do. To just name a few, number one, it could have taken the initial call from the FBI seriously. Number two, if it had an incident response plan and team, it could have triggered that team the second it learned that there was something wrong from the FBI and possibly even thwarted the ransomware attack that happened 2 days later. It could have left the college intern out of the initial meeting. There are several other things that they didn't do well that we'll talk about in some more detail. In terms of preparedness, you remember at the beginning of this, I said that the keys here to your internal cybersecurity program are awareness and preparedness. In terms of preparedness, Foodie failed on every level. They had no incident response plan. They had no incident response team. They had no idea who to call. They didn't know what to do. So having an incident response plan and an incident response team are two of the most critical issues. And so, Dan, can you tell us a little more about both of those?
Sure. But before I talk about both the team and the plan, I also want to talk a little bit about incident reporting and having a mechanism within your company so that if employees notice that they're receiving something fishy or something that seems a little bit off, that they're able to report it up the stream and it can get to IT and it can be escalated. So the employee doesn't just click something or think, oh, that is weird, but I want to ignore it, because other people may also be affected by that as well. So besides for having that reporting mechanism, which should be part of your response plan, I'll first talk a little bit about the response team. And the makeup of the team is really going to depend on the size of the company. If you have an in-house legal or in-house IT, then they really must be a part of the team. And then you also need at least one executive level person that's going to have decision-making authority. Things move really quickly in a breach, as you could see through this example, and you need someone with the authority to make decisions and make those decisions quickly. But overall, the team really should be small, and you can add people in on a case-by-case basis as you need input from other people within the company, but you do want to try and keep the team small to try and control the communication that's coming out of the team. Most importantly, as you saw through Foodie's example, your incident response team should never include an intern. Team members that are on the team should know that they're on the team. Sometimes you create this team and then you put it in a drawer, then people leave and people start and they don't know that they're actually going to have to be activated. People should be on the team, should know that they're on the team and know what their role is and understand what that role is. And then corresponding with the team is you need the incident response plan. And this really needs to be a thorough plan and well thought out amongst different levels of the organization. And that plan should activate the response team and should include information for emergency contacts of your IT vendor, of outside counsel, of your insurance broker, and also have after hours contact information for all of the incident response team members. As you can see, breaches often happen during vacation, holidays, and maybe after hours when people are a little bit more vulnerable. So to have that after hours contact information is really important. And it's important to have outside counsel have your vendor relationship set up in advance so that in an emergency situation, you're not forced to live with any unfavorable terms that exist in a service agreement. If those are negotiated in advance, you're in a better position to just start acting. And as Susie pointed out various times throughout the presentation, part of the plan should really be to develop a communication plan, which will allow you to have a unified message and be able to control that message in the event of a breach situation. And then the response plan should also address a contingency plan for the lack of access to data, as was demonstrated with Foodie. The better backups that you have and the better logs that you have, the less susceptible a company is going to be to ransomware, because they're going to be back up and running with little interruption to their systems or businesses. But to get to that contingency plan point, you really need to map out what your system is and figure out what systems that you have, what access you need, and what's most vital. And then once you have the incident response plan in place, you need to practice it. If you create this plan, you take all this time to create the plan, and then you put it in a drawer, hope that you're never going to have to use it, you're going to take the plan out of the drawer, and there's going to be dust on it in the first place, and you're not going to know exactly how it's going to work through. So you should engage your incident response team for a tabletop exercise, and then evaluate, once you go through that tabletop, adjust the plan as necessary, because there are going to be things that need adjusting. And then based on the results of the exercise, try and refine the plan and continue to practice it from time to time. Because team members are going to change within your organization. And if you have a new team member brought on, you want them to be able to also appropriately respond to the breach. So, Melissa, now that I've discussed some of the components of the incident response plan and the team, how does that really interplay with any insurance coverage that might be available?
Sure. Well, you mentioned putting the plan in the drawer and then dusting it off. I mean, insurance policies are assets. You don't purchase the policy and put it in a drawer, and you really need to, the best and most prudent cyber risk mitigation strategy is to really use the policy and the plan, and they have to work together seamlessly. So it's important to make sure you're synthesizing what's in your plan with what your obligations are to the insurance company under the policy. I mean, the policy has very specific requirements on notice, on crisis management, notification to the affected individuals, and paying a settlement or ransom. There's really not a lot you can do without getting the insurance company's permission. And if you make a payment without notifying and discussing it with the insurance company, it's what's called a voluntary payment, and it'll be excluded. They will not cover it. And one of the most important steps that a company should consider after a breach is retaining the appropriate vendors, and vendor selection continues to be a really common coverage issue at the onset of the claim. And certain policies may require that you select vendors from a pre-approved list. If they don't require that, you really, I think as Dan mentioned, you don't want to be negotiating these documents for the first time while, the bleeding is happening. You really need, first of all, you don't have any bargaining power at that point, and you're not thinking clearly. And so it's very important to have a plan where those things have been hammered out. And you don't, for the additional reason that you don't want to get involved in a coverage dispute when you're still trying to manage the breach. One additional point is that most policies actually require disclosure of the plan. The applications are very time consuming, and they want to know, what are your policies and procedures and for vendor management? What are your computer systems? What's your software? What is your breach response plan? So these are all things that they want to know. They want to know how, you're going to incorporate the requirements into that plan. So it's just very important to make sure that those things are synthesized so that it runs smoothly in the event of a breach.
And don't tell your insurance company you have a plan when you don't, because that will jeopardize your coverage too. So when filling out those applications, you've got to be honest about where you are, and if you need to fill a hole, fill it before you finish sending in that insurance application so you meet those requirements. Just a bit of a side note on the crown jewels concept that Vanessa Richards brought up earlier. One of the important parts of your incident response plan is to know and understand how the data you have will be affected. In order for you to know and understand that, you have to know and understand what information you have, where it's stored, how do you use it, how do you protect it. That's typically done in a document called a written information security plan, separate and apart from your incident plan, but it's important for every organization, as Vanessa mentioned earlier, to know what your crown jewels are, where are they, and how are they protected. If you have information on Massachusetts residents in any of your systems, that is required by Massachusetts law. In Connecticut, it's not required by law, but if you have a written information security plan and you have a breach, there's a presumption in the statute that you otherwise meet the requirements of that statute, provided that you meet all the timelines that are in there. And I know I said I wasn't going to say much about GDPR, but one final note about GDPR. The first step to GDPR compliance is knowing and understanding the data you have, where it is, how you share it, and how you use it. You can't do GDPR compliance without that first step. So that should be something that everybody is thinking about, and that then becomes part of your incident response plan. All right, next we're going to talk about backups only briefly. You've heard a lot about backups today. Backups are the most important defense you have against ransomware. If there is ransomware and you've got good usable backups that can immediately be uploaded, ransomware is not a problem. You've taken away the hacker's power. Ask the city of Atlanta how they feel about backups. We just heard last week in the news that after spending over $5 million to respond to that ransomware attack in March, they've just asked the city council for $9.5 million more to address other issues, and they revealed that they lost years of footage from police dash cams. Totally unrecoverable, gone for years. Backups would have helped in that instance. Backups would have been helpful for Foodie here too, or better backups, I should say. At least they had something. Policies and controls. Obviously, you're going to need to make sure that your policies and controls match your security needs. Your CFO should never have administrator-level access. In fact, administrator-level access should be limited just to a couple of people, and please make sure they know what a phishing email looks like. There was some study, I don't remember who did it, but that found that C-level executives are more likely to click on phishing emails than others. Do not give your C-level executives more access than is necessary, because they're also not likely to attend your training and to participate on that level. So keep that in mind as well. As you've heard a couple of times, if we had appropriate policies and procedures in place, including the written information security plan, the response plan, the incident response team, that intern would have never been in the meeting. There would have been possibly other security protocols in place that may have prevented this attack to begin with. So now is a good time for Foodie to sit back and look at what happened and see what protocols it can put in place. And then finally, training. There are few measures that are as important, as effective, and as inexpensive as training. You need to train your employees all the time. They need to know about current threats. They need to know how to respond to them. You need to send them simulated phishing emails. You need to test them, and then you need to make them aware of their mistakes. This is not a once-a-year email that comes from your head of IT say, hey, don't click on suspicious things. It is an ongoing process. You need to empower your employees to be part of that team. As I said earlier today, cybersecurity is a team sport. You need to make sure that your employees know how to avoid these situations. So I cannot overemphasize the importance of training. If you do only one thing differently when you go back to the office and you implement only one thing we've talked about today, have it be training. That is by far one of the most important things you can do. With any one of these relatively small measures in place that we've talked about, Foodie would have been a heck of a lot better off. I would like to just run through what the timeline could have looked like had Foodie done the appropriate things. So let's assume that Foodie had an incident response plan and an incident response team, and they had good backups, and let's assume all of that. But then let's also assume that the hacker still got in the system initially, or else this wouldn't be a worthwhile exercise. So day one of this incident would not have been June 14th when the ransomware was discovered, but rather day one of this incident would have been June 12th when the IT director heard from the FBI. The incident response team would have been immediately activated and in all likelihood could have prevented the ransomware issue from ever happening altogether. That incident response team would have never contained the intern. There would have been no tweet. The incident response plan would have had a list of emergency contacts, which would have included a forensic person or a forensic expert who would have been in a heck of a lot sooner, could have addressed the malware issue on the production side of things, and had production up and running within a couple of days as opposed to more than a week. And even assuming that the ransomware happened, if Foodie had good and usable backups, it would have immediately uploaded its backup information, and it would have gone back online for production as soon as the malware issue was addressed by the expert. So we're talking about a couple of days as opposed to more than a week. So there are a lot of things that could have gone much different, much better for Foodie here. You would have had customers who were less angry, employees who were less angry. You would have had less time in the media. All of that is going to impact your indirect costs and your direct costs. So that means it's going to cost a lot less money for Foodie to handle this situation. And that's the key and what we wanted to talk about today, that while we can't prevent these things entirely, awareness and preparedness is absolutely everything, because you can reduce the damage that happens to your company if you happen to be subject to one of these things. So we want to make sure that we leave some time for questions. We want to open it up. The panel is here. We want to answer any questions you have about anything that's on your mind. Yes?
Is it reasonable to ask your insurance company to help you put some of these plans together, or is that just not going to happen?
That's a good question. I mean, I think it really depends on the carrier. A lot of these things are, I don't think so much to help you put the plan together, but certainly you can glean even from the application questions what they're looking for. You know what I mean? The application, I brought a couple of samples, but it is voluminous, and the things that they're asking, it's a good indication to you. These are the things they're considering in calculating my premium. And so I need to make sure I'm putting, a plan together, and then I think really talking to an attorney to put the plan together, because then the attorney can take a more holistic approach, really understanding what it is that your business does and identifying the risks.
Does the insurer have access, or will they share with you perhaps recommended vendors for some of these?
It depends on the insurer. Some insurers do have a list of pre-approved vendors that they would prefer you use, but I think the more organized you are up front to say, hey, I have a plan in place, I've assessed the risk, this is what my plan is, these are my preferred vendors, you're more empowered to kind of go in there. You have more negotiation and more bargaining strength in saying, I want to insist on this IT professional. I had a breach 2 years ago. This is the professional I used. I have myself vetted these people and these are my preferred. And most of the time, if the conversation is happening in the application process, I have not seen an issue. I think it gets more difficult to have that conversation when you're having it in the context of an ongoing breach.
And just to follow up on your question about access to resources, while they might not give you an incident response plan, Many insurance companies will now give you the tools or an outline or information on how to create one because it's in their best interest too. Good luck getting an insurance policy these days without having an incident response plan because I don't think they'll give them to you. If you have these measures in place, it means that their costs go down if you have an incident. So they're going to want to help you put these things in place. So certainly see what resources they have for you and take advantage of them. Yes?
Recommend that a forensic team only be identified after outside counsel has been engaged, or does that start immediately?
Well, it depends on the situation. I mean, sometimes you're in a scenario where it's so critically important to get the forensic person in the door and they come in and they start work. Counsel should come in shortly thereafter. In an ideal situation, you have counsel engaging the forensic expert for you so that any report that comes from that is protected by the attorney-client privilege. The reason that's important is let's say that that report says, hey, this company should have done X, Y, and Z, and there were these problems. That's Exhibit A in the lawsuit that's going to be against the company. If you protect that under a privilege, then that's not something that's discoverable. So you can later have the law firm engage the forensic expert once they're in. You just have to be, you'd have to tweak the language a little bit to make that happen. Oftentimes when I do these agreements, I'll do them three ways. So it's the agreement between the firm, the IT vendor, and the client. And the agreement is clear that all of the communications and all the information is coming to the lawyer for the lawyer to then advise the client, and then the client is on the hook for paying that bill. Is that helpful? Yes.
Is it best to have your law firm recommend the forensic expert as opposed to you going out and actually finding one?
Yeah, so there are a couple of things to consider there. First and foremost, if you have insurance and your insurance company is demanding that you use a particular expert, you may be stuck using that expert. That doesn't mean that you have to use them. It means if you use someone else, you're going to pay for it. In terms of using an expert that your lawyer recommends, there are benefits to that because the lawyer is used to having that relationship and knows how to work with that individual. And if they've worked with them through a breach scenario before, you can rely on that lawyer's recommendation. So that may be good and useful. But again, if you're dealing with insurance, the insurance company is going to have to be on board with that selection. So to Melissa's earlier point, there really is value in saying to the insurance company, if you know who you want to use in advance, hey, if we ever have an issue, these are folks we'd like to use, and get that made part of your policy. Wow, you're all ready. You're all ready to go create your...
You have a folk up there.
Oh, hello.
Sorry, up from the top. Can you talk a little bit about the harm thresholds that you find in some of the data breach laws? And I work in financial services, and we had a few instances where we've been, I think, overly cautious as far as how we're treating them, in the sense that we weren't hacked, but we inadvertently set out information to the wrong people. And I've kind of argued that it maybe didn't quite meet the harm threshold in some of these. Could you just talk a little bit about that aspect?
Sure. And so this goes back to the fact that all 50 states have different rules. Some of the state statutes require a showing of harm in order to trigger the data breach statute, meaning that something had happened to the individual or is likely to happen to the individual. California has pending legislation that very well may go through where they're eliminating the harm threshold altogether, so that all you need is for information to have been for there to be a data breach in order to trigger the statute. So in terms of what triggers the harm requirement depends on the language in each particular statute about, is it that there's a low probability that there would be any risk to the individual. In fact, I think I have the Connecticut requirement somewhere here.
Just to chime in while she's looking for that, I think the trend here is moving towards not having a harm threshold. If you look at GDPR as what is now the gold standard, there is no threshold there. If you have just as little information as an email address, it's going to trigger the requirements under GDPR. So while all the states are still have varying terminology, I think that is the direction that we are moving. So to take a more conservative approach in terms of your reporting based on you're not sure if it's going to meet the harm threshold or not, like you're probably doing the right thing towards where we're going.
So here's the definition in Connecticut statute, but notification is not required if after an appropriate investigation and consultation with relevant federal, state, and local law enforcement agencies, the person reasonably determines that the breach will not likely result in harm to the individuals whose personal information had been acquired and accessed. That's the threshold in Connecticut. Every state is going to have different thresholds. Anyone else? All right, well, thank you so much for being here with us today. We'll hang around for a while after if anybody has any follow-up questions. Thank you.